everyone, and welcome to our Women in Sectional Title webinar on the Consolidated Practice Directives, Part 3. The fact that you've logged on and made a concerted effort to be here is a testament to the fact that our industry is filled with motivated go-getters who are thirsty for knowledge. So thank you. I'll say thank you. Perhaps the people that you're working with or for in your scheme won't, but thank you. We know that women make up a significant and growing portion of property owners in South Africa. We also know from broader housing discussions in South Africa right now that women remain particularly vulnerable when it comes to property rights, especially in situations involving disputes within schemes. In this session, we'll be unpacking Chapter 4 of the Consolidated Practice Directives dealing with disputes. When we talk about dispute resolution in sectional title schemes, it's very easy to think of it as something technical or procedural or administrative. But the truth is that disputes are deeply human. They happen where people live, where they raise children, where they feel safe or unsafe. And very often, women experience these disputes differently, not because the law treats them differently, but because the impact of these disputes lands differently in their daily lives. Think about a single woman who works a full day, comes home exhausted, is faced with a neighbor playing loud music into the night. We all know that situation. On paper, it's a noise complaint, but in reality, it's sleep deprivation. It's anxiety. It's showing up the next day, unable to function at her best, both professionally and personally. Consider harassment, subtle but persistent. A trustee or group of trustees who dismiss a woman's concern in a meeting. A community asset manager with a bullying approach over her. A neighbor who sends passive-aggressive WhatsApps that escalate into intimidation. Or a female resident who feels unsafe, using the common property because of inadequate lighting or security. Even financial disputes carry a different weight. Queries on recons, unexpected costs can hit women particularly hard, especially those managing households, navigating single incomes, or recovering from financial disruption. So when we are talking about dispute resolution today, we're not just talking about rules, CSOS processes, or legal frameworks. We're talking about dignity and safety, and the right to enjoy peaceful and undisturbed possession of our properties. Today, our conversation is about a deeper understanding of how to navigate disputes more confidently, with more authority, taking into account the CSOS directives, which were published again on the 18th of July, 2025. I do hope that you all have your large copy of your CSOS directives. If you don't and you want a copy, please email me on marina@bbmlaw.co.za and we'll send you a copy. For the community asset managers out there, you're not just managing schemes, you are managing relationships, conflict, pressure, and expectations, often all at once. Before we start with the content for today's webinar, we'd like to say to our fabulous loyal sponsors, We Connect You, a proudly South African company specializing in developing software solutions for the property management industry. Thank you. They are committed more than ever to develop superior solutions, enable seamless take-on processes, and provide dedicated training and support services. We appreciate your loyalty and input. Thank you to the guys there. To our latest sponsors, ASI Best Sure. They offer sectional title insurance with tailored risk management and insurance solutions. I'm very inspired by their dedication and their vision to be the most significant financial services insurance company in South Africa. So today, as the professionals, the problem solvers, and the emotional intelligence in the room, let's get started. Chapter 4, Dispute Resolution. Firstly, let's talk about who can bring a CSOS application in sectional title schemes. We obviously know that the registered owner can bring, or owners can apply, or the tenant can apply. But what about the occupier? Say, for example, my great aunt Jeanette lives in the scheme with me in my unit. She's not an owner, she's not a tenant, she just occupies. She can bring a matter to CSOS, she can bring an application. And of course, trustees can also apply in their capacity as trustees. Form DR1 must be completed and we know submitted to the CSOS on the CSOS Connect platform or by way of email, hand delivery or courier to the relevant CSOS regional or satellite office. All relevant documentation must be uploaded or attached. The matter will be allocated to a CMO within 3 business days of receiving and opening a file. Remember from our previous series, a CMO is a case management officer. So caution, big orange light. It is up to the applicant to ensure that all relevant information has been submitted and that the application complies with Section 39 of the Community Schemes Ombud Service Act. I think this is really a warning light here, everybody, because we've seen so many CSOS applications being kicked out for not having the correct documentation uploaded together with your application. Really important, the applicant has got to provide full name, cell phone number and telephone numbers, email addresses, and physical addresses of each person the applicant considers to be materially affected by the application. Here you might say, well, all the owners might be affected by the application. So does that mean that he or she needs to send all email addresses and physical addresses of each person? I don't think that would be necessary. I don't think that the CSOS would expect that. But they are not going to run around at CSOS, trying to get information. The applicant's got to send that information. And it's interesting to note, in the CSOS directives, it says the applicant shall limit himself to not more than 10 typed pages, excluding documents, photographs, and the like. If you want to make it longer than 10 pages, then you need, and it's typed pages, then you need the CMO's consent to make that submission longer. I don't know about you, but I've seen a lot longer submissions, and I think that it's really good that they limit it because people can ramble on about the same thing. And we need to understand that this process has to become simplified. It must become streamlined. And I think that this, sort of arduous legal, lengthy stuff is not, it doesn't have a place at the CSOS for sure. The CSOS will then communicate directly with the applicant or the authorized representative of the applicant. And communication from all the parties shall remain cordial and professional regardless of difference of opinion. Note here that the relief sought must be set out in the application and must fall within the scope of one or more prayers for relief in Section 39. This is again a really valid point because what we find is that people will just write anything that they want, and they can write, 10 or 15 prayers for relief. None of them fall into Section 39. Section 39 should be sort of taken with press stick and put up next to your desk, and you need to read through it almost every day, because every day that I read through it, and I'm supposedly an expert in this field, I find different nuances and different things that I actually didn't pick up in the first place. So Section 39 is important. Some practical advice here for anybody who's drafting a CSOS application or for community asset managers. We don't call you managing agents anymore. We call you community asset managers. Is that it is better to have less. Less is more in a CSOS application. Rather go for the things or advise people to go for the points that they're going to win. Don't put 30 prayers for relief in, because things are going to get lost, and very often it just annoys or irritates the conciliator or the adjudicator who's looking at this. Where the applicant wants to fight against a decision taken by the body corporate or the trustees, they have 60 days from that decision to do so. Also, often missed. This is often missed, and that's why things are chucked out. So if a special resolution is taken or a unanimous resolution is taken at a meeting, if the applicant, wants to query that or have it set aside, they've got 2 months in which to do so. If they're late, they have to launch an application for condonation at the same time, giving reasons for lateness. And this specific form is DRC1. Go and have a look at it. Obviously, the respondent will have their say in terms of the legal principles of audi alteram partem, which means the right to be heard, at the center of every legal dispute. The Ombud will have to make the decision around whether or not to grant condonation, to accept the lateness, and that decision is final. We can't go anywhere else. It stops there. Another interesting point to note, any information submitted by the applicant is not confidential. However, personal information will be redacted. What about this age-old question of trying to resolve the dispute internally first? It's almost as though they're forcing body corporates to say, hey, if the body corporate brings the matter or an owner brings the matter, a tenant or an occupier, what process did you follow? And people are a bit vague about this. Nobody seems to know what process they're talking about. So this process deals with trustees. It should be trustees taking on disputes and trying to arrange roundtable meetings, trying to negotiate situations between owners. But the CSOS have directed that they require proof that internal processes have been exhausted, but they are understanding if the applicant can prove that the respondent failed or refused to participate in any dispute resolution process, or if there are no trustees in the scheme to speak of, then obviously they're not going to expect any kind of internal processes to have taken place. A big green light, very happy, is that there's no fee for this application to CSOS for dispute application. So the CMO is going to assess that application received within 5 business days. And on the 6th day, if he or she decides to proceed and that they don't kick it out, they will send the dispute to the respondent. The respondent has 5 business days to respond. Once a response is received, the response is sent to the applicant again within a 5-day period, and the applicant has another 5 days to respond and to confirm that they want to proceed. Remember, business days, take out the weekends, take out public holidays. The CMO can then ask the applicant for clarification, which is important. And I must say that with these disputes, because we act for complexes or owners where they disputes sort of on the sideline, we run concurrently to the whole process, just advising our clients and drafting for them. And very often 5 days can seem like a very short time. But I think the CSOS try to stick to that in as much as is possible, unless there's very good reason that you can provide. The green light here is at any stage, while the CMO is in contact with the parties to garner information, and it becomes clear that the possibility of a settlement between the parties exists, the CMO is encouraged to pursue this possibility. So there's never a stage from when the CMO receives an application for dispute resolution that a settlement is not possible. It's not as though you're sending this application and now that's it. It has to go all the way to adjudication. Settlement is possible at any point in time. Here it is important to note that the CSOS directs that only a 5-day indulgence can be given to any party. I have to be honest, I have been given more than that. At times, but I suppose we must try and stick to that. So after receiving responses from both parties, the CSOS will make a decision to refer a matter to conciliation or adjudication within 5 business days. Be aware that if the respondent ignores all advances, they've ignored the application, they've ignored the CSOS can go straight to adjudication. Okay. Obviously, the CSOS can decide to completely reject an application and must inform the applicant for the reasons in writing. Certainly, if there are court proceedings afoot, the CSOS application will be rejected. anytime. They really get cold feet when it comes to legal process. So if anything is at court, in other private arbitrations, possibly, wherever there's another legal process, the CSOS don't want to hear about taking the matter to CSOS until those have been finalized. In addition, the application will be rejected if there are no resolutions of trustees. If the applicant is a company, but there are no signed directors' resolutions authorizing a director to bring the application to CSOS, or if the applicant is neither an owner nor an occupier of a unit and is unable to show sufficient material interest in the matter. A green light here. Good news is that if the matters can be referred directly to adjudication, and we've seen that. If the matter is urgent, it can go to adjudication, or if there's absolutely no possibility that the parties can settle the matter between themselves. Sometimes there's so much animosity and there's such a terrible history between people in a complex that, but of course you've got to motivate that as the applicant, especially. If we look at the role of conciliators, and these are trained conciliators at the CSOS, so they've got to have some kind of mediation or conciliation training under their belt. They facilitate settlement. They don't act as judge and jury ever, and they do not give legal advice, but they can draw the parties' attention to court cases or to CSOS decisions. And I think that's a very worthwhile thing for a conciliator to do, because all of a sudden it opens up the eyes of the people in the conciliation to the fact that, wow, if other conciliators have ruled in this way, then what chance do we stand? Maybe we better sign a settlement agreement. So the conciliator, once the conciliator is appointed by the CSOS and their panel of conciliators, that conciliator should give the party 7 days notice of the hearing, which is scheduled for 1 hour virtually, unless the party specifically request any kind of face-to-face meeting. I'm not sure how you feel about it, but I have to be honest, I prefer face-to-face meetings when it comes to conciliations. Conciliations are really a time to not only sit together with the parties, but also to separate the parties so that the one party goes into another room. I know you can do that virtually, but it makes a lot of sense for you to look people in the eye face to face, and to then be able to separate them, to go out and to put open-ended questions to them in a conciliation hearing, because then it sparks the flow of conversation and it's a much easier conversation to have. Okay. The conciliation, by the way, must be recorded, and no legal representation is allowed. We know that. That recording is for CSOS internal processes and cannot be handed to the parties. I did try to request a CSOS recorded mediation, and I was fobbed off, and rightly so. If the parties do reach a settlement, the conciliator will draft a settlement agreement and will send to both parties for their signature. If the parties don't return a signed contract within 24 hours, and they're quite strict on this, the matter will then be referred directly to adjudication, because you can't sit dilly-dallying and you can't start raising other queries on this conciliation hearing. Very often everybody will go home and they will have been all nice and happy and agreement's been reached, and then you'll find they'll go home and speak to their husband or wife or partner who will say, but how could you have agreed to that? That's ridiculous. You need to go back and get more out of the conciliation. And then that generally is not possible unless CSOS agree to that. If the parties do not agree on an appropriate or mutually acceptable settlement, the conciliator will issue a certificate of non-compliance, called a certificate of non-compliance, and then that will kickstart the process towards adjudication. Caution, orange light. If you attend the conciliation hearing on behalf of any party, even as a community asset manager, you require authority to negotiate that either in the form of a trustee resolution signed by 2 trustees or a power of attorney. We know that the nature of conciliation is non-adversarial and provides an environment which encourages parties to talk openly to each other. And that's why it's specifically important to understand that any information shared and any evidence relied on is completely without prejudice and is inadmissible in an adjudication or legal process. What if parties to a conciliation or adjudication don't pitch? Well, the conciliator may, on that same day, attempt to contact the absent party telephonically, by SMS, or by email. If deemed necessary and under exceptional circumstances, such as illness or death, the conciliator may set a new date or issue a non-resolution certificate. If the applicant fails, now we're talking fails to show up with no good reason, then the matter is closed. Okay, please feel free to pop any questions about conciliation or mediation into the chat box. Very happy to have a look at that and to answer all those questions. Okay, let's talk adjudication. So adjudication is based on everything, all the disputes that are set out and the remedies that are set out in Section 39 of the Community Scheme Ombud Service Act. They deal with financial, behavioral, governance, meeting, managing agent, what we call community asset manager, private and common areas, and general issues. So I thought I would extract a couple of really interesting ones which we might not be aware of. And if we have time, we'll go back to the usual Section 39 remedies. But these ones are quite interesting. First of all, you can obtain an order forcing the body corporate to take out insurance or to increase the amount of insurance. So that is within the purview of the adjudicator. And when we say forcing the body corporate to take out insurance, I think we've been to the CSOS on this. We had one building here in Edenvale, very large building. And I mean, obviously, if the trustees don't take out insurance for a building, I mean, that amounts to what in the old act used to be termed as gross negligence. And I think that is so important. And if there isn't insurance, any owner should be able to take the matter onto CSOS. So we were able to force that body corporate to take out insurance. And I remember they were saying, no, they don't have money. And the CSOS adjudicator was very clear that is a financial obligation and priority. So they needed to relook at that. An order declaring that the levy is unreasonable and adjusting the contribution to a reasonable amount. Let's just delve into this for a moment. So if Mr. X in a body corporate feels that the new increase is unreasonable, however, the increase has been okayed by a special majority, a majority at the AGM, for example, then you can still take the matter to CSOS to say why you feel the levy is unreasonable. And in certain circumstances, the people who've done this have utilized, for example, the levies in general around the area or in certain buildings around the area. But the ombud, the adjudicator, isn't really allowed to set what the contribution should be. The adjudicator in those cases would then give an order saying that they've got to go back to a special general meeting to adjust because the adjudicator feels that it's unreasonable. So it's quite tricky that it almost gives you the impression that the adjudicator can set an amount of levy. And I certainly don't think that that's the case. Have a look at another order directing the body corporate to remove unreasonable rules. We've started using this quite a lot lately because it's quite an easy one to get the CSOS or the adjudicator to do. If you feel that rules are inconsistent, not applied equally, they're unreasonable, they contrary to public policy, or that they anti-competitive, if they are discriminatory. If anybody feels that, then you can go to the ombud, and the ombud will either order, the adjudicator will order removal, or the adjudicator will order that they go back to the body corporate for further review. Declaring a meeting invalid, the adjudicator can give an award to say that a meeting is invalid, and that's sometimes on the basis that proper notice wasn't given, although usually they don't do that, because the old act used to say inadvertent omission to give notice didn't render a meeting invalid, although we don't have that anymore. There are other reasons why a meeting can be declared invalid. It's very easy lately to pick holes in meetings and how they're set up and why they should be invalid. Another order that could be looked at is declaring that a special, ordinary, or unanimous resolution passed at a meeting is void due to the fact that it unreasonably interferes with the rights of an owner or owners. So in one of my meetings, a unanimous resolution was passed declaring that a reasonably necessary, or not reasonably necessary improvement could be made. In other words, a pool could be built on common property. The one person who didn't attend the meeting was the lady who lived right next to the pool. And she raised the fact she had objected to this, but the unanimous resolution was passed all the same. And what happened here is that she took the matter to the CSOS because at the end of the day, she felt that it was her proprietary right when she bought into the complex to live without a swimming pool right next to her. And I think that was quite interesting because the old sectional title schemes, Sectional Titles Act referred to proprietary rights, whereas that word has been removed in the new legislation. So I think that the CSOS kind of in an unconscious way have woven that whole theme through this in Section 39 to say that if something, a resolution passed, unreasonably interferes with your rights, it doesn't necessarily say proprietary rights, but then you can go to the CSOS and they can declare that that is void. That resolution is void. We don't use that often enough, actually. I think we need to use it more often. Something else. An order declaring the body corporate does or does not have the right to terminate the appointment of a community asset manager is an order that you can also get in terms of Section 39. So if any owner, for example, feels particularly loyal to a community asset manager who's just been terminated, you can take that to the adjudication process too. Requiring the body corporate to carry out within a specified time, specified works to or on common property areas for the safety of owners. So that is something that I would like to use in a matter that I'm dealing with now on a building in Cape Town, where we've got common property areas which are on the facade of the building, almost like a piece of glass on the facade of the building, which is creating waterproof problems, but the engineer's report says that it's upsetting the structure of that unit, of that wall outside, and things could crumble. It's really at a bad state. That's something that the CSOS could carry out, and that would be on an urgent basis. Another award that you can look for in terms of Section 39 is declaring that an owner requires reasonable exclusive use rights over a certain part of common property that the body corporate has unreasonably refused to grant. Did you know that? And requiring that the body corporate give the rights in return for monthly or periodic payment. So that's where the gist of it is or sits, is that, you can sort of force or get an order to force an exclusive use area, but there must be payment in return for that. Also something we don't use often enough. And then obviously the final one that we all know about, but I've never really seen used in practice, is any other order proposed by the chief ombud. So I haven't seen that. Karen here, let me just see what she says. Does an occupant or tenant require the consent or authority of the registered owner to raise a dispute with CSOS? No, definitely not, Karen, definitely not. The tenant or occupant has the right on their own. They have locus standi, and they've got jurisdiction to take something directly to the ombud. Owner doesn't need to say yes. Okay, I carry on to say, a notice of set down. Okay, so we've dealt with a few interesting things from section 39. A notice of set down of the adjudication hearing shall be sent to the parties by email or courier. Note, and I mentioned this in the previous series, a read receipt confirmation shall be deemed to constitute conclusive proof that the notice was served on the party. Okay, it's not an excuse to say that the email landed in your junk mail. An adjudicator also must be a qualified attorney and acts as a judge. So adjudication has got nothing to do with conciliation. This is like the tough stuff. This is where people make decisions. Sharon says, when orders are given by CSOS, should the applicant then make it an order of the court immediately? Well, Sharon, that's difficult to say. It depends how kind of recalcitrant the respondent will be if it's against them, if that order's against them. I think it's, as a matter of course, I would probably say, yeah, it's a good idea because it's not really a huge, big deal to go make it an order of the court immediately. You know, there's a room you go to, there's certain documentation that you need to take to the registrar of either the magistrate's court or the high court, and they will do it then and there. So, I mean, why not? Because then you've got something to talk about that. We'll talk about that just now. A key principle in adjudication: if the respondent is not present for the hearing, the adjudicator can make a ruling in their absence after the applicant has laid evidence in respect of the matter. I remember going to an attorney in Johannesburg where the adjudication was held. We were the applicant. The respondent didn't arrive. And I remember clear as day being absolutely gobsmacked as a young attorney that I could actually just lead evidence and an award could be made. It's really interesting. An adjudicator has a great deal of discretion to approve or refuse requests for postponement or face-to-face hearings. All submissions must be in plain English. The directives specifically say there is no need to use legal jargon. There is a 90 business day turnaround period for dispute resolution, and the adjudicator may determine a costs order. Appeals are on a question of law only within 30 days after that. Okay. Interesting points. An adjudicator enjoys the same privileges and immunity from liability as a judge of the High Court. Opposing parties have to, another golden rule here, have to include each other in all correspondence to the adjudicator. But then I found section 51(1)(3) of the CSOS Act. I'm just going to read it to you because there's a conflict or a contradictory thing going on here. 51(1)(3) says under investigative powers of adjudicators, that adjudicators may, subject to reasonable notice being given of the time and place, come to the office of the adjudicator, or order that the applicant comes to the office of the adjudicator for an interview. That's under investigative powers of an adjudicator. I think that's quite dangerous. I think both, if I was an adjudicator, I think I would always invite both parties to whatever I'm doing, because you can always face a review based on bias. Because how do I know what you're talking about together? Not on, in my opinion. All right, the CSOS directives are also very clear that the adjudicator must apply her mind to the matter of legal representation, taking into account a party's constitutional right to legal representation. So we know off the bat that most times they don't allow legal representation at all. They don't allow it. But from what I can see personally lately, if you do put something in writing that it's a really complicated matter, then they're a little bit more open to that. From the date of the adjudication hearing, the award must be delivered no later than 14 business days and must include reasons for the decision. Now, I know that a lot of you will be saying, well, that's not our experience. Time frame is not our experience. I mean, I saw an award the other day that took 8-9 months. But we are told from the CSOS that this is being rectified and that, extra adjudicators have been appointed. We know that extra adjudicators have been appointed, and we just hope that they really start sticking to these timelines, because that would make for a streamlined process. Also, in an adjudication hearing, there is nothing stopping an adjudicator from making an order dismissing the application if it is frivolous, vexatious, misconceived, or without substance. And just the other day, yesterday, I was talking to one of our consultants, attorneys in Cape Town. He consults for our firm. And he was saying that one crowd in a building that I won't name in Sea Point has brought 8 CSOS applications over 2 months. And I think that's important to note here that, and I'll tell you later, that if there's a frivolous or vexatious, misconceived, or without substance application, there can be a cost order against that applicant to a maximum of 5,000 Rand. And here's where we need to be pushing adjudicators to impose that 5,000 Rand, because all of a sudden it costs money now to go and take these silly actions that would just waste everybody's time. What happens if the relief sought is of an urgent nature? Examples of urgency include the removal of an executive managing agent, non-compliance with undesirable rules, denial of documentation from managing agents or community asset managers, imminent harm or danger to the structure of the scheme or to people, loss, danger, and again, denial of access. So if I'm not being, if you make me sign in because I haven't paid my levies, and you don't allow me access with my access card, I'm going to go to the CSOS on an urgent basis. The CMO will give an assessment within 24 hours of an urgent matter. And if the matter is deemed urgent enough, the respondent will have 24 hours to respond. Here, the applicant must then confirm, after reading the respondent's response within 24 hours, that she or he wants to go ahead. The matter will be referred to adjudication, and the adjudicator must issue an order within 48 hours. I don't know if any of you have had experience with urgent CSOS applications. If you have, please put your experience down briefly. I think it's important that we share information. Costs orders. The directive specifically states here, everybody, that each party must pay their own costs. So, for example, if an applicant has used us as their attorneys to draft all the papers and to do everything, and they've taken it to CSOS, they are responsible for the costs. They don't give specific cost orders unless a party has done something really, really dreadful, and the adjudicator feels very strongly that they need to be punished in some way. Okay, what about if you get an adjudication order back that is blatantly incorrect, or needs clarification, or there's a word in there that totally changes the meaning of everything, and it's an error that everybody can see that there is an error. The adjudicator, in terms of our directives that we're talking about today, may issue a new order correcting spelling or typographical errors. If a party affected by the order believes that the order contains errors or omissions, she can write to a senior CSOS manager to issue a correction order. Okay, I've got an example of something where the CSOS adjudicator made an order. It was in 3 different paragraphs, and the first paragraph is completely inexplicable. We don't know which way to go. We don't know what it actually means. It's really, they need a clarification. The CSOS at the moment is toing and froing, and it eventually I had to write to the chief ombud to say, look, we can't do anything on this order because it just simply doesn't make sense. And it's something that could have easily been rectified, and I think those kind of things need to be rectified. Okay, how do you enforce a CSOS order? As we know, to enforce an award which is not being complied with, the award can be made a magistrate's court or a high court order. An order for specific performance can only be enforced in the high court. So what does this actually mean? If it's for money, if it's for arrear levies, it's pretty easy because then you get a court order depending on the amount. It will be a magistrate's court order or a high court order. And once we get the court order on a monetary amount, then we can go immediately and issue a warrant of execution against movable property. And then we can also sell that unit and apply for a Section 66 application that's in the magistrate's court to attach the unit and sell it in execution. Obviously, it's a long, drawn-out process, but it's something that we can take to the High Court or the Magistrates Court. If it's an order for specific performance to do something or to refrain from doing something, then you can only go to the High Court. Once you get that order and they still won't do whatever they're supposed to do, then you need to apply to the High Court for a contempt of court. It's a contempt of court application. And that's where things get really tricky and expensive, and it starts becoming a problem. So unfortunately with this, it's never a case of I'm going to get an award and that's the end of that. That will sort them out. Very often people will fight back and will, make sure that they either apply to the High Court to stay that and they go to appeal, or they can get very difficult and just ignore things, and that's when you have to push. And that's the legal costs involved. And the legal costs involved with that. Something to note, CSOS has no role to play in the enforcement of the order. As CSOS also has no role to play when you appeal or take a matter on appeal. You've got 30 days to appeal a matter on a question of law. And there, all our clients often write to the high CSOS saying, right, we want to appeal it. Who do we go to appeal it? We need something from you guys. It's out of their hands. It's at the High Court, and that's where it stays. Again, appeals are expensive. It's very, very tough from both parties' point of view because you're now paying High Court, you're paying advocates. It's really, really very hectic. If any of you are interested in the procedural legal side of appeals, I'm very happy to send you an article. It was a good article that was written by Fausto Di Palma, and he actually, I think, lectured on it at one of the NAMA seminars. Very good. If you want, send me an email and I'll send it to you on exactly the court process for appeals. At one stage, all the courts were doing it differently. I think that's kind of settled down now. And we've just put in an appeal, actually, for one of our very large clients who's a developer. And I would like to just see how that goes. It's always good to be on the ground at the coalface. The last thing I'd like to say is, as with mediations, applications, submitted documents, and evidence in an adjudication are not confidential. In fact, parties should be aware that adjudication orders from time to time will be published on the CSOS Connect website. So that's it for our adjudication side. I did want to say to everybody that we haven't finished our Consolidated Practice Directives in 3 series. So I would really like to carry on doing this. We still need to deal with POPI. We need to deal with annual returns. I would like to put a document together once all this is done, after the 4th meeting. Maybe that's the best way to do it. And send it, one document to you so that you've got it next to your Consolidated Practice Directives, as well as your CSOS Act and your Sectional Title Schemes Management Act. That's going to be the best way, I think, to do it. So let's not shy away from disputes. Let's step into this space with confidence and grace and intelligence. And I think it will be so helpful if all of us have the knowledge to be able to share with our clients, with our owners. If you're a trustee or an owner, at least you understand the steps and it makes it less intimidating and frightening. So thank you so much. This has been really well attended, and I'm very grateful to everybody that has told us that they enjoy the webinars and the presentation. So thank you, and we will see you next time. Take care.